Hello and welcome to News Blitz. After extensive arguments on behalf of students and of the government, the Supreme Court has finally passed orders on the NEET exam paper leak. Legacy media has reported parts of the orders without going into each aspect of the orders and explaining what it means for students and parents of the students as well. This is what we will strive to do in this analysis. Chief Justice Chandrachud had earlier said that his bench would work to preserve the interests of students, and that is more or less what the bench has done. The court passed orders even as CBI continues its investigations, which will take a lot more time to complete. In that sense, the court has worked with what it had in hand as evidence on the various aspects of the exam paper leak and not on the entire scope of it. But the fact remains that, keeping the interest of students in mind, the matter could not have been dragged indefinitely in court. Therefore, some questions on the order will certainly remain. Let us dive into the order straight away into the critical aspects of it.
There is an absence of material on the record sufficient to lead to the conclusion result of the examination stands vitiated, or that there was a systemic breach in the sanctity of the examination. Semicolon. 5. Added to the absence of conclusive material on the record at the present stage, the data which has been produced on the record, city-wise, center-wise, and the comparison for the years 2022, 2023, and 2024 is not indicative of a systemic leak of the question paper, which would indicate a destruction of the sanctity of the examination.
Firstly, the court has said there is no evidence suggesting that there was a systemic breach that requires the cancellation of the entire exam and the ordering of a re-exam for all students. The point of contention here would be what constitutes a systemic breach. As revealed in court, the leak has occurred in at least 5 states: Rajasthan, Bihar, Jharkhand, Gujarat, and Delhi. This does not mean that the leak paper has not gone wider, especially considering that a social media channel, namely Telegram, was one of the means through which it occurred. This also does not mean that the leak has occurred without the collusion of people in the system. This also does not mean that those students who procured high marks by using the leaked examination paper will get away with it, provided CBI does its job thoroughly. More on this later in this video. Incidentally, except Jharkhand, based on investigation so far, the leak occurred in BJP-ruled states. For that matter, most of the exam paper leaks have occurred in BJP-ruled states and in the BJP-dominated belt, including Gujarat. Of course, such leaks have occurred during the rule of other governments, but not in the scale and magnitude as it has occurred under the Modi regime. We have had 70 exam paper leaks in the last 7 years alone. This does not include the massive VAPAM scam which was covered up by the Madhya Pradesh government. Hence, one can argue for a long time whether this is a systemic breach or not. This is because without the system failing, the leaks could not have occurred. However, the court has kept in mind the interests of the students while taking this approach. Here it is apparent that unlike the 2015 AIPMT test for medical and dental course aspirants that got cancelled because of inability to segregate the rotten apples from the good ones, the court has segregated the beneficiaries from the others on the basis of the findings of the CBI investigation so far. Secondly, the court has considered the wider implications if the entire exam is cancelled.
Also, the court has also been mindful of the fact that directing a fresh NEET UG test to be conducted for the present year would be replete with serious consequences, some of which serious consequences for over 2 million students who have appeared at the examination, including in particular, bracket 1, disruption of the admission schedule for the commencement of medical courses. 2, cascading effects on the course of medical education, semicolon, bracket 3, a prejudicial impact on the availability of qualified medical professionals in the future.
From this video, it is clear that the court has been mindful of disrupting the entire education process and academic cycles in medical and dental colleges. If the court had to wait for the entire findings of the CBI investigation, which will take months, apart from the guilty students, it will also affect the remaining students from the 108,000 who qualified for admissions through fair means. Secondly, the court has said that depending on the final findings of the CBI, students who have indulged in the malpractices will not get away with it.
Moreover, it would need to be clarified that if the investigation reveals the involvement of an increased number of beneficiaries than those who are suspects at the present stage, action shall be pursued against any student found to be involved in wrongdoing at any stage, notwithstanding the completion of the counseling process. We'll stop. In other words, no student who is revealed to have engaged in acts of fraud or to have been the beneficiary of malpractices would be entitled to claim the vested right or interest in the continuation of the admission.
Based on the CBI's findings so far, 155 students have benefited from the exam paper leak, and there are more suspects. Even more students who benefited from the leak could be uncovered and added to the list. Such students face two consequences. One is prosecution. The accused in the crime are not limited merely to those who leaked the paper, but also to those who benefited from the crime. The other consequence is that students admitted into the courses but later found to be beneficiaries of the leak would lose their admissions. Here, it would be advisable for students who benefited from the leak to avoid enrolling for the courses at all. This is because subsequent cancellation of the exams of their admissions will expose both the students and their parents to long-lasting social stigma. Parents have paid as much as 30 lakh rupees to procure the leaked exam papers and are as much of a culprit as the ones who leaked the paper. They need to ask themselves whether it was all worth it. Thirdly, the order addresses the question of re-exam for 1,563 students.
The court had been apprised of the fact that NTA would be conducting a special test for 1,563 students in supersession of the compensatory marks which were awarded. The students were given an option of either appearing for the special test. The 1,563 students were given the option of either appearing for the special test or, in the alternative, opting for their original marks without the addition of compensatory marks.
These 1,563 students mentioned by the court got the option of re-exam because one question paper was distributed to students in some centers and a different one nationwide. When exam coordinators discovered that the wrong question paper was distributed to students, the correct one later replaced the question papers given to them. However, in the process, these students lost time. They were therefore given grace marks. The court gave the students the option to forego the grace marks and retake the exam or stick to the marks given to them. Interestingly, of these 1,563 students, only 818 opted for the re-exam. Next, the court also addressed the issue of wrong answers to questions. This occurred in the physics exams.
The answer key which was prepared by the NTA indicated that the fourth of the above options was the only correct. The fourth of the options extracted above was the correct answer. Subsequently, on a large number of representations submitted to NTA, a decision was taken to the effect that both the second of the above option as well as the fourth option would be treated to be the correct option.
As seen in the video, on this issue, the court consulted IIT Delhi to arrive at the correct answer for the physics question. Due to the wrong answer, some students got 5 marks less, some students got 5 marks more. Due to this correction, along with the grace marks given to 1,563 students, the entire ranking of the 1,08,000 students will change. This has two implications. One is that, for instance, if you qualified for admissions by a margin of 5 marks or failed to make it to admissions by 5 marks, you will find reversals. Some students will gain admissions, some will lose the admissions for which they qualified. The second implication is that those who made it or inversely failed to make it to low-cost government colleges by a margin of 5 marks will also face reversals. Some will lose admissions to government colleges and qualify for private colleges, while others who qualified for admissions to private colleges will now qualify for government colleges because of this correction. The court further passed orders to another related provision for students who had individual grievances that are not covered by the order. As seen in the video, the court has said that these students have the option to approach the high courts for redressal for their grievances. There are several such grievances. For example, one student filed a petition that he could not answer the paper properly because he has a severe problem with sweaty palms. On the other hand, rules prevented students from taking handkerchiefs into the examination halls. There are several such petitions, including those filed by physically challenged students who faced difficulties during the exams. Further, the court also paid attention to the issue of social justice for SC and ST students. As is evident from the bench's observation, the bench has made efforts to ensure that these students get social justice. Many of them cannot afford to retake the exam even if they don't have to pay for it. This is because many of them had to travel to other places in the place of their residence for the exams. This involves travel, lodging and boarding costs for 3 days. Most of them cannot afford these costs without getting into debt. Others have used the residences of well-wishers for preparing for the exams. They cannot continually keep burdening these well-wishers. These students, of course, will all the same be subject to the ranking revisions. So among the SC/ST students, some will gain admissions, some will lose it. Finally, the court addressed the conduct of the exams by the NTA along with the lacunae exposed in the proceedings.
The committee will abide by such further directions as may be issued by this court in its final judgment and order in regard to the areas which should be inquired into by it, so as to ensure that the process of conducting the NEET, UG and other examinations falling within the remit of the NTA is duly strengthened, so that the instances which came to light during the course of the present year are not repeated in the future.
The primary effort of Solicitor General Tushar Mehta, along with preventing re-exam for all students, was to give a clean sheet to the National Testing Agency or NTA. This was more a political effort on behalf of the Modi regime than an effort to get rid of incompetence in the system or an effort to expose the incompetence in the system. However, he did not succeed in covering up the failures of the NTA. For instance, how did the leak occur in the first place if the NTA had done its job well? How did students in some centers receive different question papers than those in the rest of the country? Why did the NTA fail to provide a correct answer for the physics question? If there is one primary culprit for this total mess in the NEET exams, it is the NTA. The court too is aware of it without saying it in so many words. The court ordered the constitution of a committee to ensure that such nonsense does not recur again. But we believe this is more of a political problem. This is because the Modi regime, in its attempt to saffronize the education system, has appointed incompetent academicians in crucial posts. These academicians used by the NTA got the job largely because of their ideological leanings rather than their academic competence. There is no shortage of highly competent and politically neutral-minded academicians as far as academics is concerned. The government has sacked the chairman. What about those who administered the exam and made a mess of it? What about those who framed the wrong answers? What about those who failed to monitor the distribution of two different question papers? There is a lot that the NTA has to answer for. But this is not an isolated problem. This applies to all wings of the government, not merely the NTA. This is part of the problem with the system. The government, known for its arrogance and false pride in failing to admit its mistakes, is unlikely to disturb the status quo it has set up for its own ideological and political goals. This problem needs redressal both in Parliament as well as politically on the ground. In summary, we believe that the court has done the best under the given circumstances. As it usually happens, there will be bickering over the court's reliance on certain evidences. The IIT Madras report is one example. Professors and ex-professors from IIT have stated that IIT Madras employed the wrong methods for analyzing the results. There is also a conflict of interest in this matter as the NTA chairman is ex officio member of the IIT Madras governing body. The court also says it has taken into account the objections raised by advocates for the plaintiffs with regard to the IIT Madras report and that it has done its own analysis. This is similar to Justice Khanna's bench appropriating technical expertise while stating that one cannot manipulate or tamper with EVMs. The bench hearing the NEET case neither had the time nor the expertise to analyze the data of the exam results. Likewise, what if CBI eventually finds the exam paper leak to be wider, particularly considering that the leaked paper and the answers to the questions were disseminated through the social media channel Telegram? As Advocate Sanjay Hegde pointed out, everybody who came into possession of the paper will want to profit from it because the prime motive for the leak is profit. The court too cited monetary gain as the underlying driving factor for the exam paper leak. So yes, there are some loose ends, but given the various aspects involved in the issue, especially the interest of academic cycle of students, this is a fair order. Yes, it will leave some students and parents disappointed and others happy. However, this is not something for which the court is responsible. The court only tried to sort out the mess the best it could, keeping in mind the best interest of the students. The primary onus for the crime and the mess rests with the NTA and with the Modi regime, known for its incompetence and its arrogance in admitting to its mistakes and taking corrective measures, which leads to systemic problems. With this, we now leave you requesting you to subscribe our channel, to share it, and of course give us a like by using the buttons below this video. We launched this channel recently and require all the support you can give us. We began with the NEET exam issue, but will regularly cover everything that affects the nation and its citizens without bias. Meanwhile, you could watch the video about why the government is not admitting to the NEET exam paper leak. Thank you for watching this video.